Popular Government. Sir Henry Sumner Maine. 1885. Narrated by Skeptical Waves. Essay 4. The Constitution of the United States. The Constitution of the United States of America is much the most important political instrument of modern times. The country, whose destinies it controls and directs, has this special characteristic, that all the territories into which its already teeming population overflows are so placed, that political institutions of the same type can be established in every part of them. The British Empire contains a much larger population, but its portions lie far apart from one another, divided by long stretches of sea, and it is impossible to apply the popular government of the British Islands to all of them, and to none of them can it be applied without considerable modifications. Russia has something like the compactness of the United States, and her population is at present more numerous, although her numbers seem likely to be overtaken in no long time by those included in the American Federation. All the Russian Empire is nominally governed through the sole authority of the emperor, but there are already great differences between the bureaucratic despotism of Western Russia and the military autocracy which presides over the East, and, whenever the crisis comes through which Russian institutions seem doomed to pass, the difference between the Eastern and Western systems of Russian government cannot fail to be accentuated. But the United States of America, from the Atlantic to the Pacific, from the Canadian lakes to the Mexican border, appear destined to remain for an indefinite time under the same political institutions, and there is no evidence that these will not continue to belong to the popular type. Of these institutions, the most important part is defined by the Federal Constitution. The relative importance, indeed, of the government of the United States and of the state governments did not always appear to be as clearly settled as it appears at the present moment. There was a time at which the authority of the several states might be thought to be gaining at the expense of the authority of the United States, but the War of Secession reversed this tendency, and the Federation is slowly but decidedly gaining at the cost of the states. Thus, the life and fortunes of the most multitudinous and homogeneous population in the world will, on the whole and in the main, be shaped by the Constitution of the United States. The political liberty of the United States exercises more or less influence upon all forms of free government in the older world, but to us of the present generation it has the greatest interest for another reason. The success of the United States has sustained the credit of republics, a word which was once used with a good deal of vagueness to signify a government of any sort without an hereditary king at its head, but which has lately come to have the additional meaning of a government resting on a widely extended suffrage. It is not at all easy to bring home to the men of the present day how low the credit of republics had sunk before the establishment of the United States. I called attention in my first essay to the language of contempt in which the writers of the last century speak of the republics then surviving. The authors of the famous American collection of papers called The Federalist, of which I shall have much to say presently, are deeply troubled by the ill success and ill repute of the only form of government which was possible for them. The very establishment of their independence had left them a cluster of republics in the old sense of the word, and, as hereditary kingship was out of the question, their federal constitution was necessarily republican. They tried to take their own republic out of the class as commonly understood. What they chiefly dreaded was disorder, and they were much impressed by the turbulence, the fugitive and turbulent existence, of the ancient republics. But these, they said, were not republics in the true sense of the name. They were democracies, commonwealths of the primitive type, governed by the vote of the popular assembly, which consisted of the whole mass of male citizens met together in one place. The true republic must always be understood as a commonwealth saved from disorder by representative institutions. But soon after the emancipated Americans began their great experiment, its credit had to be sustained against a much more terrible exemplification of the weaknesses of republican institutions, for the French Republic was established. The black shadow of its crime still hangs over the century, though it is fading imperceptibly into the distance. But what has not been sufficiently noticed, is its thorough political miscarriage. It tried every expedient by which weak governments, directed by unscrupulous men, attempt to save themselves from open discomfiture. It put to death all who were likely to oppose it, and it conducted its executions on a scale which, for the quantity of blood spilt within narrow limits of time, had been unknown since the Tartar invasions. It tried foreign war, and it obtained success in the field beyond its wildest hopes. It tried military usurpation, and it sent the most distinguished and virtuous of the new constitutional school of French politicians, which was beginning to control it, to perish in tropical swamps. Yet it sank lower and lower into contempt, and died without a struggle. There are not many of the charges brought against Napoleon Bonaparte which are altogether unjust, but he must at any rate be acquitted of having destroyed a republic, if by a republic is to be understood a free government. What he destroyed was a military tyranny, for this had been the character of the French government since the September of 1797, and he substituted for this military tyranny another still severer and infinitely more respected. As a matter of fact, there is no doubt that the credit of American republican institutions, and of such institutions generally, did greatly decline through the miserable issue of the French experiment. The hopes of political freedom, which the continental communities were loath to surrender, turned in another direction, and attached themselves exclusively to constitutional monarchy. American publicists note the first 15 years of the present century as the period during which their country was least respected abroad and their government treated with most contumely by European diplomacy. And just when the American Federation was overcoming the low opinion of all republics which had become common, a set of events happened close to its doors which might have overwhelmed it in general shame. The Spanish colonies in North, Central, and South America revolted, and set up republics in which the crimes and disorders of the French Republic were repeated in caricature. The Spanish-American Republicans were to the French what Hébert and Anacharsis Clootz had been to Danton and Robespierre. This absurd travesty of republicanism lasted more than 50 years, and even now the curtain has not quite fallen upon it. Independently, therefore, of the history of the United States, it would have seemed quite certain what the conclusion of political philosophy must have been upon the various forms of government as observed under the glass of experience. If we clear our mental view by adopting the Aristotelian analysis, and classify all governments as governments of the one, governments of the few, and governments of the many, we shall see that mankind had had much experience of government by the one, and a good deal of government by the few, and also some very valuable experience of attempts at combining these two forms of government, but that of government by the many it had very slight experience, and that whatever it had was on the whole decidedly unfavorable. The antecedent doubt, whether government by the many was really possible, whether in any intelligible sense, and upon any theory of volition, a multitude of men could be said to have a common will, would have seemed to be strengthened by the fact that, whenever government by the many had been tried, it had ultimately produced monstrous and morbid forms of government by the one, or of government by the few. This conclusion would, in truth, have been inevitable, but for the history of the United States, so far as they have had a history. The federal Constitution has survived the mockery of itself in France and in Spanish America. Its success has been so great and striking, that men have almost forgotten that, if the whole of the known experiments of mankind in government be looked at together, there has been no form of government so unsuccessful as the Republican. The antecedents of a body of institutions like this, and its mode of growth, manifestly deserve attentive study, and fortunately the materials for the inquiry are full and good. The papers called the Federalist, which were published in 1787 and 1788 by Hamilton, Madison, and Jay, but which were chiefly from the pen of Hamilton, were originally written to explain the new Constitution of the United States, then awaiting ratification, and to dispel misconstructions of it which had got abroad. They are thus, undoubtedly, an ex post facto defense of the new institutions, but they show us with much clearness either the route by which the strongest minds among the American statesmen of that period had traveled to the conclusions embodied in the Constitution, or the arguments by which they had become reconciled to them. The Federalist has generally excited something like enthusiasm in those who have studied it, and among these there have been some not at all given to excessive eulogy. Talleyrand strongly recommended it, and Guizot said of it that, in the application of the elementary principles of government to practical administration, it was the greatest work known to him. An early number of the Edinburgh Review, number 24, described it as a work little known in Europe, but which exhibits a profundity of research and an acuteness of understanding which would have done honor to the most illustrious statesmen of modern times. The American commendations of the Federalist are naturally even less qualified. I know not, wrote Chancellor Kent, of any work on the principles of free government that is to be compared in instruction and in intrinsic value to this small and unpretending volume of the Federalist, not even if we resort to Aristotle, Cicero, Machiavel, Montesquieu, Milton, Locke, or Burke. It is equally admirable in the depth of its wisdom, the comprehensiveness of its views, the sagacity of its reflections, and the freshness, patriotism, candor, simplicity, and eloquence, with which its truths are uttered and recommended. Those who have attentively read these papers will not think such praise pitched, on the whole, too high. Perhaps the part of it least thoroughly deserved is that given to their supposed profundity of research. There are few traces in the Federalist of familiarity with previous speculations on politics, except those of Montesquieu in the Esprit des Lois, the popular book of that day. The writers attach the greatest importance to all Montesquieu's opinions. They are much discomposed by his assertion that republican government is necessarily associated with a small territory, and they are again comforted by his admission that this difficulty might be overcome by a Confederate republic. Madison indeed had the acuteness to see that Montesquieu's doctrine is as often polemical as philosophical, and that it is constantly founded on a tacit contrast between the institutions of his own country, which he disliked, with those of England, which he admired. But still his analysis, as we shall hereafter point out, had much influence upon the founders and defenders of the American Constitution. On the whole, Guizot's criticism of the Federalist is the most judicious. It is an invaluable work on the application of the elementary principles of government to practical administration. Nothing can be more sagacious than its anticipation of the way in which the new institutions would actually work, or more conclusive than its exposure of the fallacies which underlay the popular objections to some of them. It is not to be supposed that Hamilton, Jay, and Madison were careless of historical experience. They had made a careful study of many forms of government, ancient and modern. Their observations on the ancient republics, which were shortly afterwards to prove so terrible a snare to French political theorists, are extremely just. The cluster of commonwealths woven together in the United Netherlands is fully examined, and the weaknesses of this anomalous confederacy are shrewdly noted. The remarkable structure of the Romano-German Empire is depicted, and there is reason to suspect that these institutions, now almost forgotten, influenced the framers of the American Constitution, both by attraction and by repulsion. But far the most important experience to which they appealed was that of their own country, at a very recent date. The earliest link had been supplied to the revolted colonies by the First or American Continental Congress, which issued the Declaration of Independence. There had subsequently been the Articles of Confederation, ratified in 1781. These earlier experiments, their demonstrable miscarriage in many particulars, and the disappointments to which they gave rise, are a storehouse of instances and a plentiful source of warning and reflection to the writers who have undertaken to show that their vices are removed in the Constitution of 1787-89. Nevertheless, there is one fund of political experience upon which the Federalist seldom draws, and that is the political experience of Great Britain. The scantiness of these references is at first sight inexplicable. The writers must have understood Great Britain better than any other country, except their own. They had been British subjects during most of their lives. They had scarcely yet ceased to breathe the atmosphere of the British Parliament and to draw strength from its characteristic disturbances. Next to their own stubborn valor, the chief secret of the colonists' success was the incapacity of the English generals, trained in the stiff Prussian system soon to perish at Jena, to adapt themselves to new conditions of warfare, an incapacity which newer generals, full of admiration for a newer German system, were again to manifest at Majuba Hill against a meaner foe. But the colonists had also reaped signal advantage from the encouragements of the British parliamentary opposition. If the King of France gave aid, the English opposition gave perpetual comfort to the enemies of the King of England. It was a fruit of the English party system which was to reappear, amid much greater public dangers, in the Peninsular War, and the revelation of domestic facts, the assertion of domestic weakness, were to assist the arms of a military tyrant, as they had assisted the colonists fighting for independence. Various observations in the Federalist on the truculence of party spirit may be suspected of having been prompted by the recollection of what an opposition can do. But there could be no open reference to this in its pages, and, on the whole, it cannot but be suspected that the fewness of the appeals to British historical examples had its cause in their unpopularity. The object of Madison, Hamilton, and Jay was to persuade their countrymen, and the appeal to British experience would only have provoked prejudice and repulsion. I hope, however, to show that the Constitution of the United States is colored throughout by political ideas of British origin, and that it is in reality a version of the British Constitution, as it must have presented itself to an observer in the second half of the last century. It has to be carefully borne in mind that the construction of the American Constitution was extremely unlike that process of founding a new constitution which in our day may be witnessed at intervals of a few years on the European continent, and that it bore even less resemblance to the foundation of a new republic, as the word is now understood. Whatever be the occasion of one of these new European constitutions, be it ill success in war, or escape from foreign dominion, or the overthrow of a government by the army or the mob, the new institutions are always shaped in a spirit of bitter dissatisfaction with the old, which, at the very best, are put upon their trial. But the enfranchised American colonists were more than satisfied with the bulk of their institutions, which were those of the several colonies to which they belonged. And, although they had fought a successful war to get rid of the King of Great Britain and of the British Parliament, they had no quarrel with kings or parliaments as such. Their contention was that the British King and the British Parliament had forfeited by usurpation whatever rights they had, and that they had been justly punished by dispossession. Born free Englishmen, they were not likely to deny the value of parliaments, and, even as to kings, it is probable that many of them had at one time shared the youthful opinion of Alexander Hamilton, who, while totally denying the claim of parliamentary supremacy over the British colonies, except so far as they had conceded it, had argued that the connecting, pervading principle, necessary to unite a number of individual communities under one common head, could only be found in the person and prerogative of the King, who was King of America by virtue of a compact between the colonists and the kings of Great Britain. When once, however, the war had been fought out, and the connection with the Parliament and the King alike had been broken, the business in hand was to supply their place. This new constitutional link had now to be forged from local materials. Among these, there were none for making an hereditary king, hardly any for manufacturing an hereditary second chamber, but yet the means of enabling the now separated portion of the British Empire to discharge the functions of a fully organized state, as completely as they had been performed by the kingdom from which it was severed, must somehow be found on the west of the Atlantic. The Constitution of the United States was the fruit of signal sagacity and prescience applied to these necessities. But, again, there was almost no analogy between the new undertaking and the establishment of a modern continental republic. The Commonwealth founded in America was only called a republic because it had no hereditary king, and it had no hereditary king because there were no means of having one. At that time every community without an hereditary monarchy was considered to be republican. There was a king of Poland elected for life, but his kingdom was styled the Polish Republic. In the style of the elective Romano-German Empire there were still traces of the old Roman republican constitution. The Venetian Republic was a stern oligarchy, and, in fact, the elective doges of Venice and Genoa were as much kings of the old type as those ancient kings of Rome who originally gave its name to royal authority. Many of the Swiss cantons were republics of the most primitive kind, or where the whole population met once a year in assembly to legislate and elect public officers, but one section in some cantons severely governed the others, and some cantons held their dependent territories in the hardest subjection. Nowadays, however, the establishment of a republic means the substitution, in all the functions of government, of the many for the one or the few of the totality of the community for a determinate portion of it, an experiment of tremendous and perhaps insuperable difficulty, which the colonists never thought of undertaking. The suffrage, as I shall have to show, was extremely limited in many of the states, and it is unnecessary to state that about half of them were slaveholding communities. I now propose to take in turn the great federal institutions set up by the Americans: the President of the United States, the Supreme Court, the Senate, and the House of Representatives, and, in summarily considering them, to point out their relation to pre-existing European, and especially British, institutions. What I may say will perhaps serve in some degree as a corrective of the vague ideas betrayed, not only in the loose phraseology of the English platform, but by the historical commonplaces of the Americans themselves. On the face of the Constitution of the United States, the resemblance of the President of the United States to the European king, and especially to the King of Great Britain, is too obvious for mistake. The President has, in various degrees, a number of powers which those who know something of kingship in its general history recognize at once as peculiarly associated with it and with no other institution. The whole executive power is vested in him. He is Commander-in-Chief of the Army and Navy. He makes treaties with the advice and consent of the Senate, and with the same advice and consent he appoints ambassadors, ministers, judges, and all high functionaries. He has a qualified veto on legislation. He convenes Congress, when no special time of meeting has been fixed. It is conceded in the Federalist that the similarity of the new President's office to the functions of the British King was one of the points on which the opponents of the Constitution fastened. Hamilton replies to their arguments, sometimes with great cogency, sometimes, it must be owned, a little captiously. He urges that the only alternative to a president was a plural executive, or council, and he insists on the risk of a paralysis of executive authority produced by party opposition in such a body. But he mainly relies on the points in which the president differs from the king: on the terminability of the office, on the participation of the Senate in the exercise of several of his powers, on the limited nature of his veto on bills passed by Congress. It is, however, tolerably clear that the mental operation through which the framers of the American Constitution passed was this: they took the King of Great Britain, went through his powers, and restrained them whenever they appeared to be excessive or unsuited to the circumstances of the United States. It is remarkable that the figure they had before them was not a generalized English king nor an abstract constitutional monarch. It was no anticipation of Queen Victoria, but George III himself, whom they took for their model. 50 years earlier, or 100 years later, the English king would have struck them in quite a different light. There had been a tacit compact between the first two Georges and the Whig aristocracy, that the king should govern Hanover and the Whig ministry Great Britain, and such differences as arose between the king and his subjects were attributable to the fact that European wars began in the Hanoverian department. But George III cared nothing for Hanover and much for governing England. He at once took a new departure in policy by making peace, and setting himself to conduct the government of England in his own way. Now, the original of the President of the United States is manifestly a treaty-making king, and a king actively influencing the executive government. Mr. Bagehot insisted that the great neglected fact in the English political system was the government of England by a committee of the legislature, calling themselves the cabinet. This is exactly the method of government to which George III refused to submit, and the framers of the American Constitution take George III's view of the kingly office for granted. They give the whole executive government to the president, and they do not permit his ministers to have seat or speech in either branch of the legislature. They limit his power in theirs, not, however, by any contrivance known to modern English constitutionalism, but by making the office of president terminable at intervals of 4 years. If Hamilton had lived 100 years later, his comparison of the president with the king would have turned on very different points. He must have conceded that the Republican functionary was much the more powerful of the two. He must have noted that the royal veto on legislation, not thought in 1789 to be quite lost, was irrevocably gone. He must have observed that the powers which the president shared with the Senate had been altogether taken away from the king. The king could make neither war nor treaty, he could appoint neither ambassador nor judge, he could not even name his own ministers. He could do no executive act. All these powers had gone over to Mr. Bagehot's Committee of Parliament. But, a century ago, the only real and essential difference between the presidential and the royal office was that the first was not hereditary. The succession of president to president cannot therefore have been copied from Great Britain. But there is no reason to suppose that the method of election was suddenly evolved from the brain of American statesmen. Two features of the original plan have very much fallen out of sight. The president, though appointed for 4 years only, was to be indefinitely re-eligible. The practical limitation of the term of office to a maximum period of 8 years was finally settled only the other day. And again, the elaborate machinery of election provided in the Constitution was intended to be a reality. Each state was to appoint electors, and the choice of a president was to be the mature fruit of an independent exercise of judgment by the Electoral College. Knowing what followed, knowing how thoroughly the interposition of electors became a futile fiction, and what was the effect on the character of elections to the presidency, one cannot but read with some melancholy the prediction of Hamilton, that this process of election affords a moral certainty that the office of president will seldom fall to the lot of any man who is not in an eminent degree endowed with the requisite qualifications. Understanding, then, that there was to be a real election, by a selected body, of a president who might conceivably serve for life, we must recollect that elective kings had not died out of Europe. Not long before the War of Independence, at the commencement of the troubles about the American Stamp Act, a king of the Romans who, as Joseph II, turned out to be much more of a radical reformer than ever was George Washington had been elected by the Electoral College of the Empire, and the unfortunate government called the Polish Republic had chosen its last king, the luckless Stanislaus Poniatowski. It seems probable that the framers of the Constitution of the United States deliberately rejected the last example, but were to a considerable extent guided by the first. The American Republican electors are the German imperial electors, except that they are chosen by the several states. The writers in The Federalist had made an attentive study of the Romano-German Empire, which is analyzed in much detail by Hamilton and Madison. They condemn it as a government which can only issue commands to governments themselves sovereign, but not for the mode of electing its executive head. There is some interest in observing that the electoral colleges of the United States and of the Empire failed in exactly the same way. The electors fell under the absolute control of the factions dominant in the country. The German electors came to belong to the French or Austrian party, just as the American electors took sides with the Federalists, or with the old Republicans, or with the Whigs, the new Republicans, or the Democrats. The Supreme Court of the United States, which is the American federal institution next claiming our attention, is not only a most interesting but a virtually unique creation of the founders of the Constitution. The functions which the judges of this court have to discharge under provisions of the Constitution arise primarily from its very nature. The executive and legislative authorities of the United States have no powers, except such as are expressly conferred on them by the Constitution itself, and, on the other hand, the several states are forbidden by the Constitution to do certain acts and to pass certain laws. What then is to be done if these limitations of power are transgressed by any state, or by the United States? The duty of annulling such usurpations is confided by the 3rd article of the Constitution to the Supreme Court, and to such inferior courts as Congress may from time to time ordain and establish. But this remarkable power is capable only of indirect exercise. It is called into activity by cases, by actual controversies, to which individuals, or states, or the United States, are parties. The point of unconstitutionality is raised by the arguments in such controversies, and the decision of the court follows the view which it takes of the Constitution. A declaration of unconstitutionality, not provoked by a definite dispute, is unknown to the Supreme Court. The success of this experiment has blinded men to its novelty. There is no exact precedent for it, either in the ancient or in the modern world. The builders of constitutions have of course foreseen the violation of constitutional rules, but they have generally sought for an exclusive remedy, not in the civil, but in the criminal law, through the impeachment of the offender, and, in popular governments, fear or jealousy of an authority not directly delegated by the people has too often caused the difficulty to be left for settlement to chance or to the arbitrament of arms. J. Ni pense pas, wrote de Tocqueville, in his Démocratique en Amérique, que jusqu'à présent aucune nation du monde ait constitué le pouvoir judiciaire de la même manière que les Américains. Yet, novel as was the federal judicature established by the American Constitution as a whole, it nevertheless had its roots in the past, and most of their beginnings must be sought in England. It may be confidently laid down, that neither the institution of a Supreme Court, nor the entire structure of the Constitution of the United States, were the least likely to occur to anybody's mind before the publication of the Esprit des Lois. We have already observed that the Federalist regards the opinions of Montesquieu as of paramount authority, and no opinion had more weight with its writers than that which affirmed the essential separation of the executive, legislative, and judicial powers. The distinction is so familiar to us, that we find it hard to believe that even the different nature of the executive and legislative powers was not recognized till the 14th century. But it was not till the 18th that the Esprit des Lois made the analysis of the various powers of the state part of the accepted political doctrine of the civilized world. Yet, as Madison saw, Montesquieu was really writing of England and contrasting it with France. The British Constitution was to Montesquieu what Homer has been to the didactic writers on epic poetry. As the latter have considered the works of the immortal bard the perfect model from which the principles and rules of the epic art were to be drawn, and by which all similar works were to be judged, so the great political critic appears to have viewed the Constitution of England as the standard, or, to use his own expression, as the mirror, of political liberty, and to have delivered, in the form of elementary truths, the several characteristic principles of that particular system. The fact was that, in the middle of the 18th century, it was quite impossible to say where the respective provinces of the French king and of the French parliaments in legislation, and still more of the same authorities in judicature, began and ended. To this indistinctness of boundary Montesquieu opposed the considerable but yet incomplete separation of the executive, legislative, and judicial powers in England, and he founded on the contrast his famous generalization. Montesquieu adds to his analysis the special proposition, there is no liberty, if the judicial power be not separated from the legislative and the executive, and here we have, no doubt, the principal source of the provisions of the American Constitution respecting the federal judicature. It is impossible to read the chapter, chap. Vi. Liv. 11, of the Esprit des Lois in which the words occur, without perceiving that they must have been suggested to the writer by what was, on the whole, the English practice. There were, however, other practices of their English kinsmen which must have led the framers of the American Constitution to the same conclusion. They must have been keenly alive to the inconvenience of discussing questions of constitutional law in legislative assemblies. The debates in both Houses of Parliament, from the accession of George III to the recognition of American independence, are astonishingly unlike those of the present day in one particular. They turn to a surprising extent on law, and specially on constitutional law. Everybody in Parliament is supposed to be acquainted with law, and, above all, the ministers. The servants of the Crown may not plead the authority of its law officers for their acts, nay, even the Attorney and Solicitor General may not publicly admit that they have been consulted beforehand, but have to pretend that they are arguing the legal question before the House on the spur of the moment. There is an apparent survival of these strange fictions in the doctrine which still prevails, that the opinions of the law officers of the Crown are strictly confidential. During the whole period of the bitter controversies provoked by the grievances of Wilkes and the discontent of the colonies, it is hard to say whether Parliament or the courts of justice are the proper judges of the points of law constantly raised. Sometimes a judge of great eminence speaks with authority, as did Lord Camden on general warrants, and Lord Mansfield on Wilkes's outlawry, but Parliament is just as often the field to which the perpetual strife is transferred. The confusion reaches its height when Lord Chatham in the House of Lords declares the House of Commons to be open to a civil action for not giving Wilkes a seat, when Lord Mansfield covers this opinion with ridicule, and when Lord Camden to some extent supports Lord Chatham. These are the true causes of the unsatisfactory condition of English constitutional law, and of its many grave and dangerous uncertainties. The impression made on American minds by a system under which legal questions were debated with the utmost acrimony, but hardly ever solved, must have been deepened by their familiarity with the very question at issue between the mother country and the colonies. On this question Englishmen, content as is their wont with the rough rule of success or failure as the test of right or wrong in national undertakings, have generally accepted the view which was, on the whole, that of the Whig opposition. And it must be allowed that the statesmen of the most unpopular country in Europe ought to have known that it could not attempt to subdue a great and distant dependency, without bringing its most powerful European enemies on its back. As for American opinion, the merits of the issue have been buried deep in the nauseous grandiloquence of the American panegyrical historians. Yet, in reality, the question was in the highest degree technical, in the highest degree difficult, in the highest degree fitted for adjudication by an impartial court, if such a tribunal could have been imagined. What was the exact significance of the ancient constitutional formula which connected taxation with representation? When broadly stated by the colonists, it must have struck many Englishmen of that day as a mischievous paradox, since it seemed to deny the right of Parliament to tax, not only Massachusetts, but Manchester and Birmingham, which were not represented in any intelligible sense in the House of Commons. On the other hand, the American contention is largely accounted for by the fact that the local assemblies in which the colonists were represented were not formally instituted, but grew up by themselves, because it was in the nature of Englishmen to assemble. They were a natural product of soil once become British. The truth is that, from the popular point of view, either the affirmation or the denial of the moot point led straight to an absurdity, and when the dispute was over, its history must have suggested to thoughtful men, who had once recovered their calmness, the high expediency of judicial mediation in questions between state and state acknowledging the same sovereignty. Let me finally note that the Constitution of the United States imposes, Art. 3. S. 2, on the judges of the Supreme Court a method of adjudication which is essentially English. No general proposition is laid down by the English tribunal, unless it arises on the facts of the actual dispute submitted to it for adjudication. The success of the Supreme Court of the United States largely results from its following this mode of deciding questions of constitutionality and unconstitutionally. The process is slower, but it is freer from suspicion of pressure, and much less provocative of jealousy, than the submission of broad and emergent political propositions to a judicial body, and this submission is what an European foreigner thinks of when he contemplates a court of justice deciding on alleged violations of a constitutional rule or principle. The Congress or legislature of the United States, sharply separated from the executive in conformity with Montesquieu's principle, consists, I need scarcely say, of the Senate and the House of Representatives. And here I follow Mr. Freeman in noting this two-chambered legislature as a plain mark of the descent of the American federal constitution, as it was at an earlier date of the descent of American colonial constitutions, from a British original. If we could conceive a political architect of the 18th century endeavoring to build a new constitution in ignorance of the existence of the British Parliament, or with the deliberate determination to neglect it, he might be supposed to construct his legislature with one chamber, or three, or four. He would have been in the highest degree unlikely to construct it with two. The Federalist, no doubt, seems to regard the senates of the ancient world as in some sense second chambers of a legislature, but these peculiar bodies, originally consisting of the old men of the community, would have been found on closer inspection to answer very slightly to this conception. The first real anticipation of a second chamber, armed with a veto on the proposals of a separate authority, and representing a different interest, occurs in that much misunderstood institution, the Roman tribunate. In the modern feudal world, the community naturally distributed itself into classes or estates, and there are abundant traces of legislatures in which these classes were represented according to various principles. But the estates of the realm were grouped in all sorts of ways. In France, the States General were composed of three orders, the clergy, the nobility, and the rest of the nation as the tiers état. There were three orders also in Spain. In Sweden there were four, the clergy, the nobility, the burghers, and the peasants. The exceptional two houses of the British Constitution arose from special causes. The separate parliamentary representation of the clergy came early to an end in England, except so far the great dignitaries of the Church were summoned to the House of Lords, and the knights of the shire, who represented the great mass of landed proprietors, were disjoined from the nobility, and sat with the representatives of the towns in the House of Commons. The Senate of the United States, constituted under Section 3 of the first article of the Federal Constitution, is at this moment one of the most powerful political bodies in the world. In point of dignity and authority, it has in no wise disappointed the sanguine expectations of its founders. As I have already said, it is not possible to compare the predictions of the Federalist with the actual history of the presidency of the United States, without being forced to acknowledge that in this particular the hopes of Hamilton and his coadjutors have failed of fulfillment. But the Senate has, on the whole, justified the hopes of it which they expressed. Through the medium of the state legislatures, which are select bodies of men, and who are to appoint the members of the National Senate, there is reason to expect that this branch will generally be composed with peculiar care and judgment, that these circumstances promise greater knowledge and more comprehensive information in the national annals, and that, on account of the extent of country from which will be drawn those to whose direction they will be committed, they will be less apt to be tainted by the spirit of faction, and more out of the reach of those occasional ill humors, or temporary prejudices and propensities, which in smaller societies frequently contaminate the public deliberations, beget injustice and oppression towards a part of the community, and engender schemes which, though they gratify a momentary inclination or desire, terminate in general distress, dissatisfaction, and disgust. We may not reasonably doubt that the Senate is indebted for its power, a power which has rather increased than diminished since the federal Constitution came into force, and for its hold on the public respect, to the principles upon which it was deliberately founded, to the mature age of the senators, to their comparatively long tenure of office, which is for 6 years at least, and above all to the method of their election by the legislatures of the several states. It is very remarkable that the mode of choosing the Senate finally adopted did not commend itself to some of the strongest minds employed on the construction of the federal Constitution. Its first article provides, in S. 3, that the Senate of the United States shall be composed of 2 senators from each state, chosen by the legislatures thereof, for 6 years. Hence it follows that the Senate is a political body, of which the basis is not equality, but inequality. Each state elects no more and no fewer than 2 senators. Rhode Island, Delaware, and Maryland have the same representation in the Senate, as the great and populous states of New York and Pennsylvania. The constitutional composition of the Senate is therefore a negation of equality. Now, the writer whose prediction I quoted above is Alexander Hamilton, and Hamilton himself had proposed a very different mode of constituting a Senate. His plan had been that the Senate should consist of persons to be chosen by electors, elected for that purpose by the citizens and inhabitants of the several states, who shall have in their own right, or in right of their wives, an estate in land for not less than life, or a term of years whereof, at the time of giving their votes, there shall be at least 14 years unexpired. The scheme further provided that each senator should be elected from a district, and that the number of senators should be apportioned between the different states according to a rule roughly representing population. The blended political and economical history of Europe has now shown us that Hamilton's plan would not, in all probability, have proved durable. It is founded on inequality of property, and specially on inequality of landed property. We are now, however, in a position to lay down, as the result of experience and observation, that, although popular government has steadily extended itself in the Western world, and although liberty is the parent of inequalities in fortune, these inequalities are viewed by democratic societies with a peculiar jealousy, and that no form of property is so much menaced in such societies as property in land. When the federal Constitution was framed, there were property qualifications for voting in the greater number of the American states, and it will be seen that these limitations of the suffrage were allowed to have influence in the House of Representatives. But they have given way almost everywhere to a suffrage very little short of universal, and the foundation of Hamilton's Senate would probably have undergone a similar change. Nevertheless, though inequalities of fortune are resented by modern democracy, historical inequalities do not appear to be resented in the same degree, possibly to some extent because the consideration which science has finally secured for the heredity of the individual has insensibly extended to the heredity of commonwealths. Now the Senate of the United States reflects the great fact of their history, the original political equality of the several states. Since the War of Secession and its event in the triumph of the North, this fact has become purely historical, but it illustrates all the more an apparent inference from modern European experiments in constitution building from the actual history in Europe of constitutional kings, presidents of a republic, and second legislative chambers, that nothing but an historical principle can be successfully opposed to the principle of making all public powers and all parliamentary assemblies the mere reflection of the average opinion of the multitude. On all questions connected with the federal Senate, Hamilton unconsciously took the less conservative side. Not only would he have distinguished the electoral body choosing the Senate from the electoral body choosing the House of Representatives by a property qualification solely, but he would have annulled from the first the self-government of the states by giving the appointment of the governor or president of each separate state to federal authority. The House of Representatives, which shares with the Senate the legislative powers of the United States, is unquestionably a reproduction of the House of Commons. No constitution but the British could have suggested Section 7 of Article I of the Federal Constitution, which lays down a British principle, and settles a dispute which had arisen upon it in a particular way. All bills raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments as in other bills. There is a common impression in this country, that the American House of Representatives was somehow intended to be a more democratic assembly than our House of Commons. But this is a vulgar error. The constitutional provision on the subject is contained in Section 2 of the first article, which is to the effect that the House is to be composed of members chosen every second year by the people of the several states, and that the electors in each state are to have the qualifications requisite for electors of the most numerous branch of the state legislature. The Federalist expressly tells us that the differences in the qualification were at that time very material. In every state, it adds, a certain proportion of the inhabitants are deprived of this right by the constitution of the state. Nor had the provision for biennial elections the significance which would have been attached to it at a later date. Our present ideas have been shaped by the Septennial Act, but it is quite evident that in Hamilton's day the Septennial Act was still regarded as a gross usurpation, and that the proper English system was thought to be one of triennial parliaments. Election every 2 years seems to have been taken as a fair mean between the systems of the states which made up the Federation. There were septennial elections in Virginia, which had been one of the most forward of the states in pressing on the Revolution, but in Connecticut and Rhode Island there were actually half-yearly elections, and annual elections in South Carolina. The House of Representatives is a much more exclusively legislative body than either the Senate of the United States or than the present British House of Commons. Many of the executive powers vested in the President cannot be exercised save with the consent of the Senate. And, as the Congress has not yet repealed the legislation by which it sought to trammel the recalcitrant President, Andrew Johnson, after the War of Secession, the executive authority of the Senate is now probably wider than it was ever intended to be by the framers of the Constitution. The House of Representatives has no similar rights over the province of the executive, and this restriction of power is itself a feature connecting it with the British House of Commons, as known to the American statesmen of the Revolution. The far-reaching and perpetual interference with the executive government, which is now exercised by the House of Commons through the interrogation of the ministers, was then at most high its first feeble beginnings, and moreover the right of the House to designate the public servants, who are nominally the ministers of the Crown, had for a considerable time been successfully disputed by the King. George I and George II had, on the whole, carried out the understanding that their ministers should be taken from a particular class, but George III had conducted the struggle with the colonists through servants of his own choosing, and, when the Americans were framing their constitution, he had established his right for the rest of his reign. It is to be observed that the Constitution of the United States settles the quarrel in the sense contended for by the King of England. The heads of the executive departments subordinated to the President do not sit in the Senate or in the House. They are excluded from both by Section 6 of Article I, which provides that no person holding any office under the United States shall be a member of either house during his continuance in office. We are here brought to one of the most interesting subjects which can engage the attention of the Englishman of our day, the points of difference between the government of the United States, as it works under the provisions of the Federal Constitution, and the government of Great Britain as it has developed itself independently of any express controlling instrument. In order to bring out a certain number of these differences clearly, I will first describe the manner in which the American House of Representatives carries on its legislation, and its method of regulating that occasional contact between the executive authorities and the legislature, which is inseparable from free government. I will then contrast the system with that which is followed by the British House of Commons at this moment. The difference will be found to be striking, and, to an Englishman, perhaps disquieting. The House of Representatives distributes itself, under its 10th rule, into no less than 40 standing committees, independently of joint committees of senators and representatives. The subjects over which these committees have jurisdiction comprise the whole business of government, from financial, foreign, and military affairs, to the codification of the law and the expenditure on public buildings. The 11th rule provides that all proposed legislation shall be referred to the committees named in the 10th rule. As there are no officials in the House, all bills are necessarily introduced by private members, who draft them as they please. I believe that, practically, every such bill is allowed to go to the appropriate committee, but that the proportion of them which are reported by the committees and come back to the House is extremely small. Lawyers abound in the House, and the committee, in fact, redraws the bill. Every measure, therefore, has its true beginning in the bosom of a strictly legislative body. How this contrasts with the early stages of British legislation will be seen presently. The differences in the mode of contact between the House and the executive departments differ still more widely in the two countries. This contact is governed in the United States by the 24th rule of the House. First of all, if information be required from the Secretary of State or other ministers, a resolution of the House must be obtained. Once a week, under the rule, and on that occasion only, resolutions of inquiry directed to the heads of the executive departments shall be in order for reference to appropriate committees, which resolutions shall be reported to the House within 1 week thereafter. Sometimes, I believe, the minister attends the committee, but, if he pleases, he may answer the resolution by a formal communication addressed to the Speaker of the House. This carefully guarded procedure answers to the undefined and irregular practice of putting and answering questions in our own House of Commons. The procedure of the American House of Representatives, both in respect of the origination of bills and of the interrogation of ministers, is that of a political body which considers that its proper functions are not executive, but legislative. The British House of Commons, on the other hand, which the greatest part of the world regards as a legislative assembly, though it never quite answered to that description, has, since 1789, taken under its supervision and control the entire executive government of Great Britain, and much of the government of her colonies and dependencies. There are no theoretical limits to its claim for official information, not merely concerning general lines of policy, but concerning the minute details of administration. It gives effect to its claim by questions put publicly to ministers on the Treasury bench, and, independently of all other results of this practice, the mere time consumed by the multitude of questions and replies is beginning to encroach very seriously on the time available for legislation. A singularly small number of these questions appear to have their origin in the interest which a member of the House of Commons may legitimately feel in foreign and domestic policy. Some, no doubt, spring from innocent curiosity, some from pardonable vanity, but not a few are deliberately intended to work public mischief. It is a minor objection, that the number of questions which are flagrantly argumentative is manifestly increasing. All legislative proposals which have any serious chance of becoming law, proceed in the United States from committees of the Senate or of the House of Representatives. Where are we to place the birth of an English legislative measure? He who will give his mind to this question will find it one of the obscurest which ever perplex the political observer. Some bills undoubtedly have their origin in the executive departments, where the vices of existing laws or systems have been disclosed in the process of actual administration. Others may be said to be conceived in the House of Commons, having for their embryo either the report of a committee of the House or of a resolution passed by it which, according to a modern practice, suggested no doubt by the difficulties of legislation, has taken the place of the private member's bill. But if we may trust the experience of 1883, by far the most important measures fraught with the gravest consequence to the whole future of the nation, have a much more remarkable beginning. One of the great English political parties, and naturally the party supporting the government in power, holds a conference of gentlemen, to whom I hope I may without offense apply the American name wire pullers, and this conference dictates to the government, not only the legislation which it is to submit to the House of Commons, but the order in which it is to be submitted. Here we are introduced to the great modern paradox of the British Constitution. While the House of Commons has assumed the supervision of the whole executive government, it has turned over to the executive government the most important part of the business of legislation. For it is in the cabinet that the effective work of legislation begins. The ministers, hardly recruited from the now very serious fatigues of a session which lasts all but to the commencement of September, assemble in cabinet in November, and in the course of a series of meetings, extending over rather more than a fortnight, determine what legislative proposals are to be submitted to Parliament. These proposals, sketched, we may believe, in not more than outline, are then placed in the hands of the government draftsman. And, so much is there in all legislation which consists in the manipulation of detail and in the adaptation of vaguely conceived novelties to pre-existing law, that we should not probably go far wrong if we attributed 4/5 of every legislative enactment to the accomplished lawyer who puts into shape the government bills. From the measures which come from his hand, the tale of bills to be announced in the Queen's speech is made up, and at this point English legislation enters upon another stage. The American political parties of course support and oppose particular legislative measures. They are elated at the success of a particular bill, and disappointed by its failure. But no particular consequences beyond disappointment follow the rejection of a bill. The government of the country goes on as before. In England it is otherwise. Every bill introduced into Parliament by the Ministry, and we have seen that all the really important bills are thus introduced, must be carried through the House of Commons without substantial alteration, or the ministers will resign, and consequences of the gravest kind may follow in the remotest parts of an empire extending to the ends of the earth. Thus a government bill has to be forced through the House of Commons with the whole strength of party organization, and in a shape very closely resembling that which the executive government gave to it. It should then in strictness pass through a searching discussion in the House of Lords, but this stage of English legislation is becoming merely nominal, and the judgment on it of the Crown has long since become a form. It is therefore the executive government which should be credited with the authorship of English legislation. We have thus an extraordinary result. The nation whose constitutional practice suggested to Montesquieu his memorable maxim concerning the executive, legislative, and judicial powers, has in the course of a century falsified it. The formal executive is the true source of legislation, the formal legislature is incessantly concerned with executive government. After its first birth, nothing can be more equable and nothing can be more plain to observation than the course of an American legislative measure. A bill, both in the House of Representatives and the Senate, goes through an identical number of stages of about equal length. When it has passed both houses, it must still commend itself to the President of the United States, who has a veto on it which, though qualified, is constantly used, and is very difficult to overcome. An English bill begins in petty rivulets or stagnant pools. Then it runs underground for most of its course, withdrawn from the eye by the secrecy of the cabinet. Emerging into the House of Commons, it can no more escape from its embankments than the water of a canal, but once dismissed from that house, it overcomes all remaining obstacles with the rush of a cataract, and mixes with the trackless ocean of British institutions. The very grave dangers entailed on our country by this eccentric method of legislation arise from its being followed, not only in the enactment of ordinary laws, but in the amendment of what, if it be still permitted to us to employ the word, is called the British Constitution. En Angleterre, writes de Tocqueville, la Constitution peut changer sans cesse, ou plutôt elle réexiste pas. There are doubtless strong conservative forces still surviving in England. They survive because, though our political institutions have been transformed, the social conditions out of which they originally grew are not extinct. But of all the infirmities of our Constitution in its decay, there is none more serious than the absence of any special precautions to be observed in passing laws which touch the very foundations of our political system. The nature of this weakness, and the character of the manifold and elaborate securities which are contrasted with it in America, may be well illustrated by considering two famous measures: the reform of the London Corporation, which is still unaccomplished, and the County Franchise Bill, now become law. The reconstruction of the London municipality, though a very difficult undertaking, would belong in America to the ordinary state legislatures. The legislature of New York State has, in fact, several times attempted to remodel the municipality of New York City, which has repeatedly shown itself to be corrupt, unmanageable, and inefficient, and these attempts call for no special remark, except that they have hitherto met with only the most moderate success. But a measure distantly resembling the English County Franchise Bill would be, both from the point of view of the several states and from the point of view of the United States, a constitutional amendment. In the least considerable, the least advanced, and the most remote American state, its enactment would have to be coupled with the carefully devised precautionary formalities which I described in the latter part of the second essay. If an American county franchise bill were proposed to be enforced by federal authority, the design difficulty of carrying it would be vastly greater. As a rule, the federal constitution does not interfere with the franchise. It leaves the right of voting to be regulated by the several states, gradually and locally, according to the varying circumstances of each, and the political views prevailing in it. But the rule has now been departed from in the new article, securing the suffrage to the Negroes, and there is no question that, if a measure were contemplated in America, bearing to the entirety of American institutions the same relation which the County Franchise Bill bore to the entirety of ours, nay, even if a simple change in the franchise had to be introduced into all the states, or into the bulk of them, simultaneously the object could only be effected by an amendment of the Constitution of the United States. It would therefore have to be dealt with under the fifth article of the Constitution. This article, which is the keystone of the whole federal fabric, runs as follows. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments which, in either case, shall be valid to all intents and purposes as part of this Constitution, when ratified by the legislatures of 3/4 of the several states or by conventions in 3/4 thereof, as one or the other mode of ratification may be proposed by the Congress. The mode, therefore, of proceeding with a measure requiring an amendment of the Constitution would be this. First of all, the Senate of the United States and the House of Representatives must resolve, by a 2/3 majority of each chamber, that the proposed amendment is desirable. The amendment has then to be ratified by the legislatures of 3/4 of the several states. Now, there are at the present moment 38 states in the American Union. The number of legislatures which must join in the ratification is therefore 29. I believe, however, that there is no state in which the legislature does not consist of 2 houses, and we arrive, therefore, at the surprising result that, before a constitutional measure of the gravity of the English County Franchise Bill could become law in the United States, it must have at the very least in its favor the concurring vote of no less than 58 separate legislative chambers, independently of the federal legislature, in which a double 2/3 majority must be obtained. The alternative course permitted by the Constitution, of calling separate special conventions of the United States and of the several states, would prove probably in practice even lengthier and more complicated. The great strength of these securities against hasty innovation has been shown beyond the possibility of mistake by the actual history of the federal Constitution. On March 4, 1789, the day fixed for commencing the operation of the new federal government, the Constitution had been ratified by all the states then established, except 3. One of the first acts of the new Congress was to propose to the states, on September 25, 1789, a certain number of amendments on comparatively unimportant points, which had no doubt been suggested by the discussions on the draft Constitution, and the several states ratified these amendments in the course of the following year. An amendment of more importance, relating to the power of the Supreme Court, was declared to have been ratified on September 5, 1794, and another, remedying a singular inconvenience which had disclosed itself in the original rule regulating the election of the President and of the Vice President, had its ratification completed in September 1804. After these early amendments, which were comparatively easy of adoption through the small number of the original states, there was no change in the federal constitution for 60 years. The 13th, 14th, and 15th Amendments, which became part of the Constitution in the period between the beginning of 1865 and the beginning of 1870, were the fruits of the conquest of the South by the North. They abolish slavery, provide against its revival, forbid the abridgment of the right to vote on the ground of race or color, impose penalties on the vanquished adherents of the seceding states, and incidentally give a constitutional guarantee to the public debt of the Federation. But they could not have been either proposed or ratified, if the South had not lain under the heel of the North. The military forces of the United States controlled the executive governments of the Southern states, and virtually no class of the population, except the Negroes, was represented in the Southern legislatures. The War of Secession, which was itself a war of revolution, was in fact succeeded by a revolutionary period of several years, during which not only the institutions of the Southern states, but the greater part of the federal institutions were more or less violently distorted to objects not contemplated by the framers of the Constitution. But the form of the federal institutions was always preserved, and they gradually recovered their reality, until at the present moment the working of the Constitution of the United States does not, save for the disappearance of Negro slavery, differ from the mode of its operation before the civil convulsion of 1861-65. The powers and disabilities attached to the United States and to the several states by the federal Constitution, and placed under the protection of the deliberately contrived securities we have described, have determined the whole course of American history. That history began, as all its records abundantly show, in a condition of society produced by war and revolution, which might have condemned the great Northern Republic to a fate not unlike that of her disorderly sisters in South America. But the provisions of the Constitution have acted on her like those dams and dikes which strike the eye of the traveler along the Rhine, controlling the course of a mighty river which begins amid mountain torrents, and turning it into one of the most equable waterways in the world. The English Constitution, on the other hand, like the great river of England, may perhaps seem to the observer to be nowadays always more or less in flood, owing to the crumbling of the banks and the water poured into it from millions of drainpipes. The observation is, however, worth making, that the provisions of the Constitution of the United States which have most influenced the destinies of the American people are not always those which the superficial student of it would first notice. Attention is easily attracted by Article 4. Section 4, which makes the United States guarantee to every state in the Union a republican form of government, and, on the other hand, protection against domestic violence, and again, by Sections 9 and 10 of Article I, are which prohibit the United States and the several states from granting titles of nobility. No man can mistake the importance of the portions of the first article which forbid the several states to enter into any treaty, alliance, or confederation, to make anything but gold or silver coin a tender in payment of debts, and, without the consent of Congress, to keep troops or ships of war in time of peace. But a hasty reader might underestimate the practical effects of the provisions in Article I, which empower the United States to promote the progress of science and the useful arts, by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries, and, again, of the parts of the same article which prohibit the United States and the several states from laying any tax or duty on articles exported from any state, and, lastly, of the remarkable provision which forbids a state to pass any law impairing the obligation of contracts. The power to grant patents by federal authority has, however, made the American people the first in the world for the number and ingenuity of the inventions by which it has promoted the useful arts, while, on the other hand, the neglect to exercise this power for the advantage of foreign writers has condemned the whole American community to a literary servitude unparalleled in the history of thought. The prohibition against levying duties on commodities passing from state to state is again the secret both of American free trade and of American protection. It secures to the producer the command of a free market over an enormous territory of vast natural wealth, and thus it secondarily reconciles the American people to a tariff on foreign importations as oppressive as ever a nation has submitted to. I have seen the rule which denies to the several states the power to make any laws impairing the obligation of contracts criticized as if it were a mere politico-economical flourish, but in point of fact there is no more important provision in the whole Constitution. Its principle was much extended by a decision of the Supreme Court, which ought now to interest a large number of Englishmen, since it is the basis of the credit of many of the great American railway incorporations. But it is this prohibition which has in reality secured full play to the economical forces by which the achievement of cultivating the soil of the North American continent has been performed. It is the bulwark of American individualism against democratic impatience and socialistic fantasy. We may usefully bear in mind that, until this prohibition, as interpreted by the federal courts, is got rid of certain communistic schemes of American origin, which are said to have become attractive to the English laboring classes because they are supposed to proceed from the bosom of a democratic community, have about as much prospect of obtaining practical realization in the United States as the vision of a cloud cuckoo burrow to be built by the birds between earth and sky. It was not to be expected that all the hopes of the founders of the American Constitution would be fulfilled. They do not seem to have been prepared for the rapid development of party, chiefly under the influence of Thomas Jefferson, nor for the thorough organization with which the American parties before long provided themselves. They may have expected the House of Representatives, which is directly elected by the people, to fall under the dominion of faction, but the failure of their mechanism for the choice of a president was a serious disappointment. I need hardly say that the body intended to be a true electoral college has come to consist of mere deputies of the two great contending parties, and that a presidential elector has no more active part in choosing a president than has a balloting paper. The miscarriage has told upon the qualities of American presidents. An electoral college may commit a blunder, but a candidate for the presidency, nominated for election by the whole people, will, as a rule, be a man selected because he is not open to obvious criticism, and will therefore in all probability be a mediocrity. But, although the President of the United States has not been all which Washington and Hamilton, Madison and Jay, intended him to be, nothing has occurred in America to be compared with the distortion which the presidency has suffered at the hands of its copyists on the European continent. It is probable that no foreigner but an Englishman can fully understand the Constitution of the United States, though even an Englishman is apt to assume it to have been much more of a new political departure than it really was, and to forget to compare it with the English institutions of a century since. But, while it has made the deepest possible impression on continental European opinion, it has been hardly ever comprehended. Its imitators have sometimes made the historical mistake of confounding the later working of some of its parts with that originally intended by its founders. And sometimes they have fallen into the practical error of attempting to combine its characteristics with some of the modern characteristics of the British Constitution. The President of the Second French Republic was directly elected by the French people in conformity with the modern practice of the Americans, and the result was that, confident in the personal authority witnessed to by the number of his supporters, he overthrew the Republic and established a military despotism. The President of the Third French Republic is elected in a different and a safer way, but the ministers whom he appoints have seats in the French legislature, mix in its debates, and are responsible to the lower house, just as are the members of an English cabinet. The effect is, that there is no living functionary who occupies a more pitiable position than a French president. The old kings of France reigned and governed. The constitutional king, according to M. Thiers, reigns, but does not govern. The President of the United States governs, but he does not reign. It has been reserved for the President of the French Republic neither to reign nor yet to govern. The Senate has proved a most successful institution except in one particular. Congress includes many honorable as well as very many able men, but it would be affectation to claim for the American federal legislature as a whole that its hands are quite clean. It is unnecessary to appeal on this point to satire or fiction. The truth is, that too many Englishmen have been of late years concerned with congressional business for there to be any want of evidence that much money is spent in forwarding it which is not legitimately expended. One provision of the Constitution has here defeated another. One portion of the sixth section of the first article provides securities against corruption on the part of senators and representatives, but the portion immediately preceding provides that senators and representatives shall have a compensation for their services, to be ascertained by law and paid out of the Treasury of the United States. This system of payment for legislative services, which prevails throughout the whole of the Union, has produced a class of professional politicians, whose probity in some cases has proved unequal to the strain put upon it by the power of dealing with the public money and the public possessions of what will soon be the wealthiest community in the world. It is a point of marked inferiority to the British political system, even in its decline. It may be thought that a great American institution failed on one occasion conspicuously and disastrously. The Supreme Court of the United States did not succeed in preventing by its mediation the War of Secession. But the inference is not just. The framers of the Constitution of the United States, like succeeding generations of American statesmen, deliberately thrust the subject of slavery as far as they could out of their own sight. It barely discloses itself in the method of counting population for the purpose of fixing the electoral basis of the House of Representatives, and in the subsequently famous provision of the fourth article, that persons bound to service or labor in one state shall be delivered up if they escape into another. But, on the whole, the makers of the Constitution pass by on the other side. They have not the courage of their opinions, whatever they were. They neither guarantee slavery on the one hand, nor attempt to regulate it on the other, or to provide for its gradual extinction. When then, about 70 years afterwards, the Supreme Court was asked to decide whether the owner of slaves taking them into one of the territories of the Union, not yet organized as a state, retained his right of ownership, it had not in reality sufficient materials for a decision. The grounds of its judgment in the Dred Scott case may have been perhaps satisfactory to lawyers, but in themselves they satisfied nobody else. It is extremely significant that, in the one instance in which the authors of the Constitution declined of set purpose to apply their political wisdom to a subject which they knew to be all important, the result was the bloodiest and costliest war of modern times. Let me repeat the points which I trust I have done something towards establishing. The Constitution of the United States is a modified version of the British Constitution, but the British Constitution which served as its original was that which was in existence between 1760 and 1787. The modifications introduced were those, and those only, which were suggested by the new circumstances of the American colonies, now become independent. These circumstances excluded an hereditary king, and virtually excluded an hereditary nobility. When the American Constitution was framed, there was no such sacredness to be expected for it as before 1789 was supposed to attach to all parts of the British Constitution. There was every prospect of political mobility, if not of political disorder. The signal success of the Constitution of the United States in stemming these tendencies is, no doubt, owing in part to the great portion of the British institutions which were preserved in it, but it is also attributable to the sagacity with which the American statesmen filled up the interstices left by the inapplicability of certain of the then existing British institutions to the emancipated colonies. This sagacity stands out in every part of the Federalist, and it may be tracked in every page of subsequent American history. It may well fill the Englishmen who now live in Fis Romuli with wonder and envy.